Good afternoon. I'm Jim Townsend. I'm director of the Levin Center for Oversight and Democracy at Wayne State University Law School. It's my pleasure to welcome you to today's panel discussion entitled, How Our Courts Are Shaping Congress's Power to Investigate. Thank you for joining us. Now, before I turn things over to my colleague, Elise Bean, who will moderate today's panel, I want to say a few words about the Levin Center and how this discussion relates to our mission. So the late Senator Carl Levin founded the Levin Center in 2015 with the mission to advance bipartisan fact-based oversight as crucial instruments of our democracy. We are headquartered at Wayne State University Law School. We also have an office in Washington, D.C. And in the past few years, the Levin Center has trained hundreds of congressional staff in the techniques of bipartisan fact-based oversight, which we're now bringing that training to state and local lawmakers as well as legislators overseas. We also support and conduct research and scholarship on government transparency and accountability, and advocate for the right of the legislative branch to conduct oversight to ensure that government keeps its promises. So that's what we're here to talk about today. If you want more information about the Levin Center, I hope you'll visit our website, levin-center.org. So back 3 years ago now, in January of 2020, we held a panel at the National Press Club in Washington, D.C. to examine recent developments in litigation related to Congress's power to investigate and obtain information. And I remember thinking that it had been an uncommonly busy few years in the courts on this topic. Now, gathering here today to take stock of the last 3 years, having a lot of litigation in this area doesn't seem so uncommon anymore. And with, I guess, recent developments in Congress, who knows how much more litigation there may be in the next few years. So there is much to discuss. Before I turn things over, I do want to say a word about Elise. She directs the Levin Center's Washington office. Elise spent 30 years working for Carl Levin as an investigator in the Senate, where she served as staff director and chief counsel of the Permanent Subcommittee on Investigations. Elise recently published a book on her years leading PSI's investigations into financial issues, and she is frequently called upon to comment on oversight and conduct or consult with investigative committees on how they approach their work. I want to again thank our distinguished panelists for being here today to unpack these issues. And I want to thank our audience again for joining us here today. And Elise, with that, please take it away.
Thank you, Jim, for that kind introduction. For 50 years, the federal courts saw relatively few cases involving congressional subpoenas, requests for information, or other investigative matters. But less than about 10 years ago, that began to change. An influx of new cases culminating in the Supreme Court's Mazars decision in 2020 created a wealth of new case law. 2020 is also the year that the Levin Center held its first review of case law developments in the oversight field. Today, we're offering another review to help the oversight community keep up with how the courts are shaping Congress's power to investigate. So let's get right to it with some introductions of our outstanding panelists. First, I'd like to introduce Doug Letter, who served as the general counsel for the U.S. House of Representatives for the last 4 years. During that period, he engaged in nonstop litigation defending Congress and court, including arguing multiple cases before the Supreme Court. He and his team racked up a remarkable win-loss record, upholding the oversight rights of both the House and Congress as a whole. Emily Berman is professor of law at Houston University Law Center. In 2020, she won the Levin Center Award for Best Oversight Research Paper of the Year, in which she dissected the ways in which the Department of Justice Legal Counsel's Office had defended the executive branch against congressional requests for information. Andy Grewal is professor of law at Iowa College of Law, specializing in tax, administrative law, and constitutional law. Last year, students voted him as the College of Law's Professor of the Year. Will Ortman is Professor of Law at our own Wayne State University Law School, specializing in criminal law, evidence, and criminal justice issues. He too has been voted Professor of the Year on more than one occasion by Wayne's upper-level law students. So today we're going to be taking advantage of these talented lawyers by asking each of them to make a brief presentation on a group of cases decided on congressional oversight issues over the last 2 years. After each presentation, all 4 panelists will comment on that group of cases. When all 4 presentations are complete, we'll open up the dialogue to a broader discussion of case law developments in the oversight field. Viewers, you are invited to submit any questions you may have for the panelists using the Q&A function on your screens. We hope to include your questions in the discussion, so ask us what you'd really like to know. Okay, so we're going to begin the discussion today by asking each of the panelists to engage in what we call a lightning round and take just 2 minutes apiece to provide some opening observations about the court rulings over the last 2 years related to the power of Congress to investigate. So let's start with Doug.
Thank you very much, Elise, and I'm so delighted to be here again, I think. So in this lightning round, I'm going to talk really, really fast. There's way too much to cover. And I look forward to being able to talk more later in the program. As you probably know, many of the cases, if not all the cases we're going to be talking about today, are ones that that I litigated over the last 4 years as the general counsel of the House, as otherwise known as Nancy Pelosi's lawyer. There was so much law that was set during that period. And the one thing I do ask that people keep in mind is that the House, it's a new House every 2 years. And so the House has to conduct its investigations very quickly with a compressed amount of time. And so the more litigation there was, the more difficult it was for the House to get its work done, because the courts, some of them moved fast, some of them moved just incredibly slowly. As Elise mentioned, I won a whole batch of cases, but a lot of times, frankly, it was either too late or almost too late to make much of a difference. So one way that the court, we're going to talk a lot about how the courts ruled in various cases, but one thing that is very important to keep in mind is the courts had an enormous impact on the House, at least, because they were slow. And that is something that really mattered. I'm going to be later talking about in more depth the by far, I think, the most important case for me to address is the subpoena that was directed to Mark Meadows, the White House Chief of Staff, and his challenge to that. I hope to also get into the litigation over the subpoena for the records of the Republican, not the records of Salesforce, a contractor for the Republican National Committee, and then the records of T-Mobile phone records for Dr. Ward, who was at the time the chair of the Arizona Republican Party, one of the leaders in trying to overthrow the election of 2020. She was a real focus of some of the investigation by the January 6th committee, because she took many actions of a very serious nature trying to overthrow the election by the people of the United States. Anyway, I suspect my 2 minutes are up.
Sure. So thanks, Elise, and to the Levin Center for having me. As Doug says, there's so much to discuss. I think the whole panel is going to sound a bit like a lightning round, but as far as where I think I would like to start, sort of 30,000-foot view, in my view, in the past couple of years, cases have established precedent thanks to Doug and his team, that in almost every instance give Congress more leverage than it has had in the past to conduct investigations. And I think that the executive branch has long benefited from a lot of ambiguity surrounding rules about Congress's access to the information. And many of the cases that we talk about today resolved some of those ambiguities, at least in Congress's favor. And so having resolved some of those issues about, even if it's preliminary issues like standing and the availability of a cause of action, those are going to have a lot of influence going forward, because as the House negotiates over information in the future, they're going to be negotiating in the shadow of all of this new law that has been created. And in fact, I think that President Trump's unwillingness to negotiate and compromise may have, as Doug said, may have benefited him. He was allowed to run out the clock on a lot of things, and other witnesses of interest to the 1-6 committee in particular were able to run out the clock on a lot of things. But by insisting on judicial resolution of some of these issues, those witnesses and President Trump, I think, did more to empower Congress by not cooperating than Congress could have done on its own. So that's all to the good for Congress. At the same time, I think the sort of sui generis nature of the 1-6 attack permeates a lot of these opinions in a way that raise questions for me about how impactful some of the precedents might be going forward, since the facts in most cases, we can hope, are going to be easily distinguishable from what happened on 1-6. So on the one hand, I think there's been a lot of progress forward for Congress's authority, and I think how impactful that will be remains an open question that I'm interested to see how it plays out.
Thank you, Emily. Andy Grewal, you're up.
Thanks, Elise. So a lot of the cases, or several of the cases we're going to talk about today, will involve congressionally initiated lawsuits, House committee versus someone else. And I think we should, as we go through them, think about whether these cases should even exist. Elise pointed out in the last 10 years, there's been a flurry of cases, and they've been unusual compared to the last 50 years. I think maybe we should look a little bit broader. If we look at the history since 1789, this idea of the legislature instituting a lawsuit was unknown. It was a group of legislators in the 1920s filed a suit. The court dismissed it. In the 1970s, in the Nixon era, is when we first saw a House or Senate authorized suit. And in the last 10 years, in my view, things have gone a bit overboard. I do think that we might see some resolution of this eventually when we look at the consistent views of the executive branch. Justice then Judge Ketanji Brown Jackson famously or infamously said that Trump was acting like a king in the McGahn case when the DOJ took the position that Congress, the House or the Senate, cannot ever sue the executive. Yesterday, the GSA filed a petition of cert with the Supreme Court challenging the standing of Congress under a statutory rule to sue the executive branch. In their petition, the Biden administration, like the Trump administration, takes the position that Congress can never, ever sue the executive branch. So we've seen this consistent view between the Trump administration, Biden administration, Bush, Obama, all of them saying that Congress should never be able to sue the executive branch. And so that's just something I want to keep in mind as a backdrop as we go through these cases. Is our courts the proper resolution forum for a congressionally initiated lawsuit? I would say no. I wouldn't go so far as to say Doug letter shouldn't exist, but maybe we don't necessarily need a litigator. Congress should legislate, not litigate. And I look forward to talking more about the substance of the cases later on. Thank you.
Great, thank you, Elise. It's great to be here. So my corner of this is criminal law, and the 117th Congress was a big one for criminal enforcement in the oversight space. So I put together a little graph that just put some context in that in terms of guilty verdicts and contempt of Congress cases. So give you some sense, it's been about 50 years before last year since the last time a jury found somebody guilty of contempt of Congress, couple near misses, but then we get the Steve Bannon case. So I'll be talking towards the end of this panel about the Steve Bannon case in some detail to tease that discussion just a little bit. I think there's a very real possibility that Bannon's conviction does not survive appeal. And if that happens, if that comes to pass, the likely reason is one that would have, I think, pretty significant ramifications for oversight going forward. So I'll get into that. We'll also talk about the other contempt of Congress case that's currently still pending in the DC District Court, which is Peter Navarro. And then that raises some of the same issues as Bannon. But then there's also cases where the DOJ asked, or the Congress, where the House asked DOJ to prosecute, and DOJ politely said no. So Dan Scavino and Mark Meadows. So those implicate this recurring, longstanding question about whether DOJ ought to be saying no thanks when Congress asks it to prosecute. And then finally, the other sort of criminal world encounter with oversight and oversight-related topics is Lindsey Graham's efforts to have a federal court enjoin his subpoena to testify at the grand jury in Atlanta. So he tried to stop that, invoking speech or debate. He failed, and we'll get into that as well towards the end of this panel.
Responses showed us just how much ground we have to cover. It's pretty amazing what's gone on in the last 2 years. So now we're going to each panelist and have them summarize a particular group of cases. The 4 categories we will consider are cases involving subpoena enforcement, privilege issues, tax information, and criminal prosecution. So we're going to start by having the particular panelist give us a presentation, and then we'll take a little bit of time to talk about that particular group of cases. Once we get all 4 complete, we'll have that larger dialogue that I talked about earlier. So let's start with the man who was in court all the time, Doug Letter.
Thank you again, Elise. And I'm looking forward very much I want to respond to, in particular, some of the things that Andy said. So I'm looking forward to the lightning round at the end. I think I get to go last. And so I will devastate everything he said in my last 2 minutes, and then we will end. So Elise asked me to, I think I litigated all of these cases, but let me start with the Meadows case. I think is absolutely fascinating for a number of reasons. So here we have the chief of staff in the White House. And so I know a number of you are saying, well, of course we can't have the chief of staff of the president being forced to come in and testify. But before you just take that view, I ask that you focus closely on what was actually involved in Meadows, because this is something we thought about very, very carefully. None of these were things where, a bunch of idiots got together and just reflexively said, let's sue, let's send subpoenas, etc. I know lots of people want to portray it that way. It was not. This was a group of people who were extremely intelligent, well-informed, and had a strategy that was well worked out and discussed. So Meadows received a subpoena for documents and testimony. At first, he was very cooperative. He provided, I think it was about 2,100 of his own text messages. He provided, I think, about 1,300 documents. So right away, by the way, everybody needs to understand the subpoena that the House issued was extremely effective, because without any legal proceedings at all, Meadows provided very key information. And from the January 6th report that you can read over Emily's shoulder there, you can see that some of the things that he turned over were extremely key. Conversation like a January 6th, Donald Trump Jr. texting Meadows saying, "Oh my God, you've got to stop this. The president has to do something." You know, like, duh, of course he does. He didn't, but anyway. So what? Then we had that Meadows was going to come in for a deposition. Everything was all set, and then last second he said no, and then claimed he had claimed executive privilege, marital privilege, attorney-client privilege, and absolute immunity. But there were a number of problems with this. One was that he'd already turned over a whole batch of material. Two, he'd written a book where he talked about a whole lot of things publicly. So that raises, everybody obviously has red flags going up about, wait a minute, you can write a book and go on talk shows, et cetera, and try to sell it and then claim privilege over that material? What a joke. So the other really important thing is here, the January 6th committee limited its subpoena. When we eventually briefed this, because Meadows sued in court, we said that we were focusing on a specific number of points that we wanted to get from Meadows. And one of them was, he's already, we want to talk to him about the things he's already disclosed to us. And we thought, it's really hard for somebody to claim privilege when you've already disclosed the key things, and we want to ask you about them. That just seems like an amazing abuse of privilege that the courts at least would never stand for in litigation. But notice, if you look carefully, we issued the subpoena and said we were limiting it to what the Office of Legal Counsel of the Justice Department limited executive privilege to, which is the official actions of the White House Chief of Staff, various officials. Now, here's the key. Under federal law, somebody in Meadows's position and the other officials in the White House were barred by federal law from using their official positions to attempt to influence political campaigns. That they were not allowed, that was against the law to do that. So we said, all we're doing, therefore, is asking for Meadows's unofficial stuff at this point. Meadows already turned over a fair amount of his official stuff. So unless Meadows wants to say, oh yeah, I violated the Hatch Act, love doing it, as other members of the Trump administration did, he put himself between a rock and a hard place. Because remember, Meadows participated, for instance, in the infamous dealings with the Secretary of State, for Georgia, Raffensperger, trying to get Georgia officials to commit, I think, criminal violations by overriding the votes of the citizens of Georgia. Meadows also participated in what was probably criminal activity, trying to get fake electors to pretend that they actually were electors and send in authorizations, reports on votes to Congress, et cetera. So these were all things that could not be official. They were not part of his official duties, and therefore they couldn't be covered by executive privilege as the Justice Department described it. So we said this is the kind of thing that we were focusing on at that point. And obviously very interesting issues, when you're dealing with the president and his chief of staff. Is the Hatch Act constitutional if it says that they can't use their office, their official office that the people of the United States are paying for, to try to override elections, et cetera? So as I say, I ask that you focus closely on that as anybody comments on the Meadows case. What then happened was even more interesting, it seems to me, because Judge Nichols at a certain point said, I'm going to dismiss Meadows's case because of the speech or debate clause privilege. And very quickly, the speech or debate clause privilege is in the Constitution. It's absolute immunity. The framers knew exactly what they were doing. They took the lessons from English history, kings trying to punish members of parliament, and they decided they were going to put that in the US Constitution. It is right there, and it's absolute. Criminal, civil makes no difference as long as it's part of a member's legislative functions. It is absolutely immune. I repeat, criminal, civil, absolutely immune. So you can get on the floor in Congress. You shouldn't do it, but you could read out classified information, put it in the public record. It's a criminal violation, protected, absolutely immune. So Judge Nichols said when Meadows sued the members of the House, the January 6th committee, they're absolutely immune. Now, I argued, well, but wait. It's not self-executing. It's jurisdictional, but not self-executing. And we had chosen not to assert that immunity. And therefore, the case could go forward, just like, other cases. And for instance, we know the House and the Senate can, at least the courts recognize the House and the Senate can sue to enforce their subpoenas. And that seems to be valid according to the DC Circuit. But if somebody tries to raise other claims, those can be barred by speech or debate. That's privilege. That's Senate Select Committee. Okay, I'm under a warning here, 2 minutes. Then we've got the Ward case, Ward and RNC. The January 6th committee was under an obligation to look into what happened, not just on January 6th, because, we know. You can read police reports. No. Why were all of these people trying to attack the Capitol? Why did they think that there actually had been fraudulent elections when, as we know from 60-something court proceedings, there weren't? There were none. There was no valid evidence, none. Again, 60-something court proceedings rejected these claims. So what happened? How did President Trump and others sell this big lie to the American people? So we said, well, we need to look at who was communicating with whom. And this constant drumbeat about fraud that was, as I say, was a lie. So we did use modern investigative techniques to find out who was communicating with whom. We did not violate the law. There's a statute that provides for getting phone records, but the House and the Senate cannot get content under that law. So we made absolutely clear we were not getting content. We were merely getting connections. So we saw it from T-Mobile, the records, telephone records of Ms. Dr. Ward in Arizona, because she was, as I said before, she was in the heart of trying to overturn your election, the election that you all voted for. I hope you all voted. And we went, who was she talking to? What was going on here? And same thing, the Trump people, Trump campaign was using all sorts of mechanisms of modern communications technology to try to convince the American people that there had been fraud. They were trying to sell the big lie. And so the RNC was part of that. Very, very sad. Very, very sad. And that was, they did it through a technology company, Salesforce. So we went to Salesforce and said, we want records. And so we were trying to get those records, and RNC sued. District court said we were entitled to those records. Case though went up on appeal. Again, it dragged out way too long to be of use. We had other investigative techniques, discovered other material, and so we decided not to pursue the case further. In the Ward case, Ward took it to the Ninth Circuit. We prevailed. Ward took it to all of her arguments were rejected. She took it to the Ninth Circuit. She lost there before an emergency motions panel, and then she lost in the Supreme Court. Two justices dissenting, saying that it was on the shadow docket. Two justices said they would have heard her case, but 7 said no. There's just nothing here. It could be resolved on the shadow docket. I'm guessing that my time is either expired or about to, so I'll leave it right there.
Well, thank you, Doug, for talking about those subpoena enforcement cases. Do any of the other panelists like to make a comment on these category of cases involving trying to enforce or challenging enforcement of a subpoena?
Sure.
Go ahead.
So I found Judge Nichols's ruling in the Meadows case just pretty remarkable. And Doug, maybe I'm hoping you might be willing to say more about it. So the contortions, the legal contortions that the judge had to go through, not just in how the court ruled on the speech or debate immunity, but also just to reach the question, I thought were pretty remarkable. And you didn't get a chance to appeal because time ran out. And I don't know if you, Meadows would have appealed, but I don't know what position you would have taken if there had been. So a couple of sort of interesting implications or things that arise to me out of that. So one is Judge Nichols takes the position that the House did not waive speech or debate, even though it didn't raise it. It didn't raise that as a reason to dismiss the lawsuit. And it seems to me there had to be pretty interesting strategic considerations that went into that decision about waiving and or not raising from the House. And I don't know, Doug, if you can comment on those, but I would be very curious. The other is I wonder if we take this decision literally, what implications it has for Congress's inherent authority, right? So if we're going to say that speech or debate even extends to declaratory or injunctive relief, does that mean that there is no possibility of any judicial review of inherent contempt procedure in the House or the Senate? I find that pretty remarkable as well.
I would love to. Thank you. Yes, Will, you've raised how fascinating this ruling from Judge Nichols was. By the way, I consider Judge Nichols a friend. I have immense respect for him. I think this is a situation of Homer nodded. Yeah, we did not waive. We deliberately decided that we would defend that lawsuit and not raise speech or debate. And by the way, I raised on behalf of the House speech or debate quite a few times during my 4 years, and I think I won every single one of them. But we decided that members decline to raise speech or debate all the time. For instance, an FBI investigation, the members not being investigated, somebody else is, but the members often, I sat in on them, would meet with the FBI and explain this or that, and chose not to raise speech or debate. That happens all the time. I said that to Judge Nichols, but he decided to get rid of the case on that ground. But you're right. This raises this fascinating question of, it appears to mean that nobody can ever sue the House or the Senate to try to stop a subpoena and enforcement of it, because it would be covered by speech or debate. It's jurisdictional, and that's the end. Now, as we know, the House could sue to enforce and somebody could try to defend, or what you could do is, the House can go back to what it did, before, about 100 years ago, McGrain versus Doherty. We can start arresting people, and then they can raise, habeas defense. And you're going to hear from Andy in a little while. If the House cannot sue to enforce, that's one of the big things that is pushing for, it seems to me, is we're going to start having a big beefed up sergeant at arms office, and we're going to go start arresting people. And there is a House jail, will be expanded considerably, and we'll just arrest people from now on. And that's how this will go. And we'll have basically trial by combat, rather than having it decided by the courts. So anyway, yes, those are very good observations, Will.
So that Meadows case really raises that big issue about when can the target of a subpoena challenge it. I want to mention one other case very briefly, just because something happened in it yesterday, and so it seems to be another issue of interest. And this is the case that people call the Rule of 7 case. There is a statute that allows a request for information by people on the House Oversight Committee and also in the Senate Homeland Security and Governmental Affairs Committee, if more than 7 members of that committee, not a majority, it's still a minority, but if they make a request for information to an executive branch, the executive branch agency has to respond. So 7 members asked for information from GSA related to the Trump organization's lease of the old post office. The district court said they didn't have standing to enforce that information request. The DC Circuit reversed and said they did have standing. And now that has been appealed to the Supreme Court. And yesterday, the members of Congress filed their brief urging the Supreme Court not to take the case for various reasons. So I just want to see if anybody has a comment on that case, because it's another kind of very unusual development in the courts, allowing a minority of members on a certain committee to get information. So somebody other than the chair of the committee. Any comments on that?
I'm
Yeah,
happy to toss in or to wait. Why don't I'll wait. I'm sorry,
Andy, why don't you go ahead?
Yeah, I'll just toss in an interesting aspect about that case is that in Rains v. Byrd, the Supreme Court held that an assembled group of legislators lack standing to sue the executive branch. The GSA case is interesting because Congress has passed a statute authorizing them to do so. And Rains said, we attach some significance, we won't say how much, to the fact that the House or Senate hasn't authorized this suit. In some sense, that issue isn't present in the GSA case. So the Supreme Court is going to be asked to determine, well, what if you do have a statute? Then can an isolated group of legislators, not a committee or the entire House, will they have standing to sue? Again, in my view, no, but it is different from Rains v. Byrd on one of the factors that the court in Rains itself gave as a potential distinction. So I think that it's a major case to watch with major implications, because the court could take the case and decide just on the basis of this 7-member statute. That's one thing they could do. Or they could go broader and really set the law or clarify the law on congressional standing. So I think that's potentially a blockbuster case that those of us interested in congressional oversight should keep an eye on.
And I think another distinction is the Rains case didn't involve oversight, but this one does. And so it's an oversight question specifically, which also makes it interesting.
Although I mean, I guess the argument is that the absence of oversight perhaps strengthens the standing argument, because they want information. And we know under FOIA, typically it's very, very, very easy to establish standing under FOIA,
Yes.
almost negligible. So the argument might go is that, well, if not getting information is an injury under FOIA, then not getting information under the 7-member rule is also a judicially cognizable injury. And not my view, but I can understand why the DC Circuit resolved the issue the way they did, and why the Supreme Court should take it up.
I think it's going to be pretty fascinating to see how that turns out.
I
Doug, I'll
agree. I
let you have
think
the last word, but then we're going to move on to our next section.
Sorry, very fast. I think everything Andy said is exactly right. This really could be a blockbuster case, and it's definitely something that that needs to be watched. The other issue is, as I raised internally, this group knows. So what happens if there's 7 members? This was in, as I recall, 2018. So let's say there's 7 members then. Now, I think there's only 3 or 4 of them left in Congress. And so what happens then? And second is, this came up while I was House counsel. The House did not file a brief in the case. Is what if those 7 members are actually in the majority? And let's say one of them, just suppose for a moment, was a committee chair with power to issue a subpoena. Would that in some way moot the case or make it so that it undermines standing even more, because they don't even need that statute anymore because they have subpoena power from one of their members is a plaintiff. So anyway, other
So it's a hypothetical, but I'll let you know it was 17 members to begin with. It's a lower number now, just as you predicted, Doug, but I don't think it's fallen under 7. And the people are in the minority. So we may have that mootness danger, I think, is not present right now in the House.
I thought it was under 7, but I may be dead wrong. You may be
No,
right.
17 people to begin with. Some have fallen off, but I don't think it's gotten under 7. All right, so now that was an amazing topic to begin with, subpoena enforcement. Now let's talk about another really important issue over the last 2 years, which is privilege. And Emily, please give us your thoughts about that group of cases.
Sure. So there are several types of privilege. I'm going to touch on each briefly. The first is the presidential communications privilege, also known as executive privilege. Then there was an important case about presidential immunity. And then finally, attorney-client and work product privilege also came up in one of these oversight cases. So first, the executive privilege case was Thompson versus Trump. And this was a case where the 1-6 committee sought Trump administration records from the National Archives. And President Biden declined to assert executive privilege over those records, at which point former President Trump sued to block their release to the committee, making essentially 2 arguments. The first, that the committee lacked a valid legislative purpose. And secondly, that his assertion of executive privilege over those records, trumped President Biden's decision to waive privilege with respect to those materials. The district court declined President Trump's request for an injunction barring the release of these materials, and the DC Circuit affirmed, essentially rejecting both of the former president's arguments, first saying that Congress had a compelling need to investigate, and second, that Congress's need for the information outweighed any potential claim of executive privilege. The Supreme Court also declined to issue an injunction over a dissent from Justice Thomas, and with an interesting sort of concurring statement by Justice Kavanaugh. So a couple of points about the DC Circuit and Supreme Court opinions. I think on the one hand, this case is quite a strong affirmation of congressional oversight power. For the first time, a court confirmed that Congress's need for information can outweigh a claim of executive privilege. As everyone may know, executive privilege is a qualified privilege that could be overcome by a sufficient showing of need by the party seeking the information. But to date, no appellate court had held that a congressional subpoena, as opposed to one coming from a grand jury, could ever meet that standard. And in this case, there was a lot of discussion in the appellate decision about the relative strength of privilege assertions by the president versus privilege assertions by the former president. But in the end, the court said essentially, it doesn't really matter because the committee is entitled to these documents, even if the privilege was being asserted by an incumbent president. So even if the person in the strongest position to assert executive privilege was claiming privilege, Congress's need still outweighs the executive privilege. And so I think that holding, which the Supreme Court did nothing to question in its own brief discussion of the case, really calls into question a long-standing view of the executive branch on their sort of narrow conception of when Congress can potentially show a need that outweighs executive privilege. So that I think is quite significant on the executive privilege front. At the same time, the DC Circuit also took great pains to stress the unique nature of this case and the fact that Congress's interest in investigating January 6th is uniquely weighty. And so subsequent disputes over information could easily distinguish this case on its facts if they want to talk about maybe Congress's need not being sufficiently weighty in the future. So do we need an attack on the Capitol trying to overturn an election for Congress's need to overcome executive privilege, or is this going to have more general significance than that? The next privilege or immunity I'll discuss is the presidential immunity. And this came up in, there were 3 consolidated cases brought by members of the House of Representatives in their personal capacities, and a couple of Capitol Police officers against President Trump, some of his associates, and organized militia groups like the Proud Boys and the Oath Keepers, for both statutory and common law violations taking place on January 6th itself. And the district judge in the case issued a 112-page opinion saying many interesting things, but for my purposes, the important part of that opinion addresses President Trump's claim that he is absolutely immune from liability under a case called Nixon versus Fitzgerald. And that case alleged that President Nixon violated a former government employee's First Amendment rights by firing that employee for exposing cost overruns in the Air Force during a congressional hearing. And the Supreme Court held in that case that the president is entitled to absolute immunity from damages liability arising out of his official acts, based basically on concerns that if presidents are going to be subjected to liability for their official acts, that's going to divert their energies and attention away from doing their very important job. And it really established quite broad immunity, saying that this absolute immunity extended to acts within the, quote, outer perimeter of the president's official responsibility. Here, however, the court said this immunity does not apply because the acts on which the suit was based, things like President Trump's pressure on local election officials and the vice president, president's planning in and participation in the January 6th rally, that all of those acts concern his efforts to remain in office for a second term, not his official acts as president. And so rejected this claim of presidential immunity. The DC Circuit held arguments in this case at the beginning of December, and all 3 judges, including one Trump appointee, seemed very skeptical of this claim of presidential immunity. And there was a lot of debate over where one might draw the line between official and unofficial acts. But it seemed to be the sentiment of the panel that sort of wherever you draw the line, here we're dealing with presidential action that, in their words, approaching incitement to violence, that is clearly on the wrong side of the official versus unofficial acts line, and so it shouldn't apply here. So again, unclear whether this is a one-ride ticket that only applies in this extreme circumstance, or whether this is more meaningful with respect to limiting presidential immunity going forward. And then the final case I'll mention is Eastman versus Thompson, which is the case where the January 6th committee sought communications from Chapman Law professor John Eastman, who has been one of the architects of the pressure campaign on Mike Pence and on efforts to arrange for states to submit alternative slates of electors. And Eastman claimed attorney-client and work product privilege over hundreds of documents that the committee sought. And I think the case was actually most notable, or at least was noticed publicly mostly, for the fact that the judge found in that case that it was more likely than not that President Trump and Professor Eastman participated in an unlawful conspiracy such that the crime fraud exception to attorney-client privilege actually applied. But there were a couple other aspects of the court's decision in this case that I think are interesting as it applies to sort of the evolution of the law of privilege. And one was about what they call dual use documents. So if a lawyer is both litigation counsel and a political advisor to his client, as Eastman was to Trump in this instance, only those documents whose primary purpose relates to a pending or anticipated litigation are going to be protected by work product privilege. So a lot of documents that were about the sort of false electors plan, there was nothing to do with litigation in the future that was involved in most of those documents, and therefore the court said that doesn't qualify as work product and is not privileged. The other interesting holding that the judge made is that attorney-client privilege is not waived by using a law school email account, a holding that did not help the January 6th committee, but did prompt sighs of relief from law professors everywhere, that if you use a law school email account, even if there's a policy that the university can monitor that account, that in itself is not sufficient to waive any sorts of privilege. So I think I'm probably out of time. As with the first set of cases, there's much more to say about all of these, but I will pause there and see what my co-panelists have to say about these.
Thank you, Emily. That is another amazing set of cases to talk about. Do any of the other panelists have any comments or observations that they would like to make?
Yeah, I think the cases Emily mentioned, I think, reflect an overall tenor of Congress not wanting to really get involved. I think Emily pointed out that the court, in one of the cases, the court upheld Congress's authority under any plausible standard. In the cases I'm going to discuss, the court did the same thing. They didn't want to define one standard or another. They say, even if you take the most heightened standard, Congress wins. I think the judges are left to decide the case in front of them, but the overall tenor of these cases from the last few years, and probably going forward, at least within the lower courts, I think the Supreme Court's going to be different. In the lower courts, I think we really have seen a vindication of Congress's authority in numerous areas.
I just had one quick comment. I thought Emily did an excellent job in describing these. In my mind, one of the high points was during one of the arguments before Judge Carter, as he was considering these, was that there was a claim of attorney-client privilege for a whole lot of documents, and I pointed out to the judge that the claim for attorney-client privilege covered a message about when Professor Eastman was recommending that his client commit I forget whether it was, I think he said a small violation of the law. That small violation of the law, by the way, was to violate the law and try to overturn the popular election. I said to Judge Carter that I've been practicing law for about 45 years. To my knowledge, I had never once recommended that my client commit a violation of the law. And if I had, I didn't think I would claim attorney-client privilege over that when I got caught. And that really did seem to resonate with Judge Carter.
That's a fun inside tip there about what the discussion was like with the judge. I'd like to read one of the questions we've gotten from one of our viewers, Michael Stern, who is a leading scholar in the Oversight area. He asks, in Eastman, the committee did not assert that Congress has the power to disregard the attorney-client privilege. Do you think the Mazar's decision made it more difficult to make that argument, particularly in a case where the client was the president? Emily, what do you think?
Yeah, I mean, one thing about a lot of the sort of compromises that the committee made in that particular case, and that sort of agreement to go along with decisions that they might not necessarily have agreed with, I don't think it's going to inhibit them from making different arguments going forward. I think that there are all sorts of debates over information, particularly between Congress and the executive, end up in these accommodated resolutions where people sort of give up what they would otherwise claim to be rights that they have or immunities that they have without prejudicing their power to assert those going forward. And in fact, we've seen, the executive branch has Office of Legal Counsel opinions that talk about district court decisions and say, well, the district court decided something contrary to what our office believes, but that's not binding on us, and we think they're wrong. And so we're going to continue to maintain this legal position. And so I don't think it prejudices Congress's claim to do anything necessarily going forward. Whether the Mazars case has more to say about that is a separate question. But with respect to this particular case itself, I think it's important to keep in mind that Congress didn't necessarily give up any claims that it might want to make going forward.
And I'd like to
If I
point
could-
out that the Levin Center gave its award for the best oversight research paper of the year this time around to Georgetown professor David Rapallo, who wrote a paper about the significance of the one line in the Mazars decision where the Supreme Court said, of course, Congress is subject to the attorney-client privilege, when there is a very long, detailed history of Congress saying we are not subject to that court-created privilege. So that's an issue for another day, but I think that was a very interesting paper and worth reading. So we're going to move on now to our third segment with Andy, who is going to talk about tax information issues, which also had a fascinating course of action this year in the courts. Andy.
Yeah, I'm going to do my best to hit the high points of the Mazars case, as well as the Ways and Means v. Treasury case in my 10 minutes. Please interrupt me when I hit the end. So the first case, Mazars, related to President Trump suing to block the service or the enforcement of a subpoena against his financial service firm. And this is the one that actually went all the way to the Supreme Court, in which the Supreme Court remanded to the DC Circuit to apply a different standard. And so the opinion that came out, and which is our interest today, is the one issued by the DC Circuit on remand. And really the main takeaway from that case is that the court in that opinion applied the Mazars standards for presidents, even though we are now dealing with a former president. Right? Usually when it comes to a congressional subpoena, it's a relatively lax standard, legitimate legislative purpose. That's not a terribly high standard. Courts don't want to double check. And the Supreme Court in Mazars is the kind of the short version, is that the Supreme Court said, well, if Congress is subpoenaing the president's information, courts have to, one, look at the legislative purpose very closely. The subpoena must be reasonably tailored. The quality of evidence must be strong, and you have to pay special attention to the burdens placed on the president, among other potential factors not stated. And so the issue for the courts in Mazars on remand is that President Trump lost the election, and now he's not president anymore. Do you continue to apply the same standard? The court kind of had a funny line in rejecting the committee's argument. The committee argued that no, he's not president anymore. You don't apply these standards. And the court says, well, we're not going to not apply Mazars in Mazars itself. So the court said, at least in these circumstances where the subpoena was served when President Trump was president, we are going to apply these heightened factors. I suppose formally speaking, the court leaves open what would happen if the subpoena was truly issued to a former president or with respect to a former president. But on these facts, when it's going to a president while he or she is president, the court says Mazars is going to continue to apply. And then the court's opinion is fairly long. Essentially, the committee offered 3 investigative tracks, and the opinion goes through and narrows the subpoena in relevant respects for each of the stated tracks. And that is, the committee asserted issues related to emoluments, GA oversight, and conflicts of interest. And the court, in a very detailed opinion, I thought it was very thorough and scholarly, says, well, you can get some information and not other. So I suppose whoever won that case depends on the perceptions of the parties. One takeaway from that case that I noticed is that the court accepted this successor and interest theory. As Doug pointed out early, the House is different from the Senate. The Senate is a continuing body, 1/3 swaps every couple of years. The House, you get a new House every 2 years. That makes subpoena enforcement difficult. even if you have the same political party in control. And the court said, well, the subpoena was issued in 2018 and reissued in 2021, and we're not going to start everything anew just because, formally speaking, there was a new House. They accepted that the new Congress could be a successor in interest to the earlier Congress. Now, if the political parties change, then you just have a practical issue. Presumably, if the parties switch, the new Congress might withdraw for political reasons or other good reasons. But even if you have, let's say, a Republican House now, after Mazars, at least within the DC circuit, you don't have to start anew if the case hasn't been resolved by 2023 and a new House steps in. So that's a major takeaway. If this is correct, this kind of 2-year ticking time bomb for the House isn't necessarily a ticking time bomb. It can go on longer. The other case, Ways and Means, this was a congressionally initiated lawsuit against the executive branch. This one took a while because the court below didn't want to really touch this case until the McGahn case was resolved. McGahn is where the DC circuit, after lots of winding back and forth, the panel decision in banc and so on, the court ultimately held that Congress did have standing to sue the executive branch. And then the lower court decided, all right, that question's been settled. Let's hear whether this subpoena or statutory request more precisely is valid. So the Ways and Means case, it's a little bit different, maybe not in constitutional respects, but descriptively, there's a statute in the tax code that says that the chairman of specified committees can himself or herself request information from the Treasury. Now, the interesting question is that addressed by the court at the DC circuit is, well, is this statute facially unconstitutional? Earlier, I mentioned that Congress ordinarily must act with a legitimate legislative purpose. This statute doesn't say Congress with a legitimate purpose can get any information it wants. The statute just says the chairman can get any information he wants without any limitation or qualification. So viewed one way, the statute is facially unconstitutional. But the court says, you know what, that's not how we're going to analyze this statute. We're going to, if we're dealing with a statute that criminalizes private conduct and it's on its face overbroad, fine, we'll strike down that statute. But here, this statute is detailing how the government interacts with itself, legislature and executive. And so is there any conceivable way that this statute could be applied constitutionally? And the court says yes, if the chairman or chairwoman in fact has a legitimate legislative purpose. I think that's a little bit weird. I think the court was adding words into the statute, but ultimately no harm, no foul. The court ultimately decides that the statute is not facially unconstitutional because you could imagine circumstances in which a request did have a legitimate legislative purpose. Another takeaway from that case relates to the perception of motives, which I thought was a little bit odd. The court says because of the speech and debate clause, we are not going to examine whether individual congressmen and congresswomen had ill motives in pursuing or pushing the chairman to request the tax returns. And it may be, I think it's sound to not dig into the minds of legislators, but it was odd for me to hear the court say that the speech and debate clause is a relevant authority. To me, speech and debate clause means it's a personal right. You cannot sue Congressman Y or Congresswoman X. They can individually assert the speech and debate clause. This is not a lawsuit against any particular legislator. It's not even a lawsuit against Congress. It's a lawsuit initiated by Congress. No one is questioning Congress here in a personal sense. If the court says a speech and debate clause is relevant, you can't even talk about the motives. Again, if you were suing a particular congressman or congresswoman for libel or slander, I agree. Speech and debate clause plainly protects the legislator. But does that mean that in a case not involving an individual legislator, you're not even allowed to talk about the issues? Again, no harm, no foul, because I don't think it's particularly sound to try to psychoanalyze legislators, but I thought the reference to the speech and debate clause was a little bit strange. In any event, the court ultimately decides that the statutory request is valid pursuant to the constitutional statute. And as I was mentioning earlier, it does it under this, we don't care which standard you apply. This is going to meet even the heightened standard. You could apply the Mazars test, which the court ultimately did. So, you know, this kind of looks like the law of the circuit, that in our Mazars case, we did on remand, we did apply these heightened factors. And now we have a different case. We've kind of already decided that we're going to follow Mazars. So the court did so. The court also says, well, we're not certain about which standard is going to apply, and maybe the Supreme Court's going to take this up. So we'll also look at the GSA standard. And the court also makes swift work of a First Amendment claim. And I won't go into further detail in that in the interest of time. So yeah, I think I got it all within 10 minutes. Thank you very much.
Thank you, Andy. That was a wonderful discussion of those two complicated tax cases that really had a lot of new case law. Do any of the other panelists like to comment on those cases? Well, I'd like to ask you, Andy, now that we've gotten through those two cases, do you think the courts have strengthened or weakened Congress's ability to get tax returns under 6103F? And do you think that this Congress is now going to follow up on what they claimed was their legislative purpose, which is to look at the auditing process at the IRS?
Yeah, I mean, this is an interesting question about motives, right? When Trump issued the travel ban, everyone kind of knew, he had a sense in his mind of what was behind it. The Supreme Court doesn't want to look at tweets. We know, everyone kind of knows what the motive is, but you don't really look at it in a judicial case. Ditto here. There was no doubt about what the legislators wanted to do. They wanted to get Trump's returns and wanted to release them. Every thinking man knew that was a purpose. Is that something that a court takes into account? They say, we're not going to dig into the motives. What has happened since they won the case? Again, we all knew what was going to happen. They got him. They lost in Congress. They released him very quickly. Everyone knew that was a real reason for the request. So in our formalistic legal sense, did they attach some proposal of oversight to the Treasury when they released Trump's tax returns to the public? Yeah, so in a formal sense, it is consistent with oversight. But again, we all knew what was really happening, right? That it was vindicated, not by just their own words, but by the fact that they did release them almost as soon as they got them. So it's interesting what'll happen later on. I still don't think, I don't think that injury to the tax system is a fact will occur in court. I don't think a future court is going to say, well, this committee told us that they weren't going to release them. They did it anyway. Maybe a district judge might do that, but I don't think that's how courts typically make this decision. They're not going to go into political acts, and they're going to look at this institutionally. So in a very formalistic sense, I do think the case ultimately strengthened the authority of Congress to get tax return information, which has already been extremely broad. This was a very unusual case. Congress has been getting tax return information for nearly 100 years. You don't have lawsuits over it typically. So in a formal sense, yes. In a political sense, I was disappointed by what the committee did and basically releasing so quickly. I think there's an injury in a political sense, but in a formal sense, Congress's oversight authority has been broadened.
I'd like to just disagree with one aspect of your analysis, which is I really do think there should be an oversight effort looking at the failure of the IRS to audit the president's tax returns despite their own policy. And maybe there should be a law requiring that, since the IRS was just disregarding its own requirements. But I hear what you're saying. And
just to be clear, I totally agree with you 100%. My issue was, is that a pretext or not? That was a limitation of my analysis. You're absolutely right. There should be oversight. Tax system is extraordinarily important, totally valid. And Elise, I think you're on twice and we're getting some feedback on your second line.
I don't know why I'm on twice.
Elise, may I comment very briefly?
Please do.
I just and again, I think Andy did a terrific job on describing the issues and what happened. I did want to though say one thing, because I was very heavily involved in it. When and I'm not sure, I may have misunderstood something that Andy said. We didn't. I never told the courts that we would not disclose. I said I had no authority to say that the committee could disclose, might, etc. And Judge McFadden, and as I recall, the DC Circuit specifically noted that. But the one thing I wanted to say, Andy, was the committee, the Ways and Means Committee and the Joint Committee on Taxation, as soon as the returns were provided and the return information and the IRS notes, they looked at them, and as they then said in a report, it was immediately obvious that the IRS had not done what their program said they were to do. It was immediately obvious that they were not actually carrying out what we would consider an appropriate audit, and had not been done. So I think you're right. If there is a situation where returns come in and then just immediately released, that's one thing. Here, even though there was a short time, again, it was immediately obvious, and the staff director of the Joint Committee on Taxation, which is totally nonpartisan, his explanation that is public, he said expressly, it was immediately obvious that the IRS was not doing what it had, what its regulations said. Its policies said what it was to do. So I did want to point that out.
Okay, I think it's time to move on to our last segment with Will to talk about criminal prosecutions.
Great, thanks. So the big criminal law headline from the last Congress was that the House sent 4 contempt citations to DOJ, and DOJ actually indicted in half of them. So only the Bannon case has gone to trial so far. Of the 2, I'll start with that. And I suspect people are familiar with the background. So the January 6th committee sends Bannon a subpoena for testimony and for documents. He, I would like to say politely, but probably not politely, says no. His lawyer tells the committee that because Trump had supposedly invoked executive privilege, he could disregard the subpoena entirely. So the House, well, the committee, and then the House, and then DOJ, and then a jury all say, no, Mr. Bannon, that's not the way that this works. So Judge Nichols, who comes up again in this panel, sentences him to 4 months, though, and this is interesting, he stays the sentence pending appeal. All right, so in a lot of ways, the Bannon prosecution is a really simple case. The defense team threw a lot of spaghetti at the wall, but there was not all that much that sticks. So just to list off some of the issues where there's really not an issue. So the committee subpoena was valid. He didn't comply with it. The executive privilege claim that he raised was really without substance. I think it fails for somewhere in the neighborhood of 3 and 30 independent reasons. So that stuff is clear. But then there's this sleeper issue in the case, which I alluded to in the lightning round, I think might have some big implications. So when Bannon gets his subpoena, his lawyer purportedly tells him, Steve, you cannot comply with the subpoena because Trump has invoked executive privilege. Now, that was not good legal advice, in my opinion, but Steve Bannon is not a lawyer. So isn't he entitled to rely on his lawyer's advice? So the district court's answer to that was no, he's not. And the district court was legally correct because there is this 1961 DC Circuit case that holds that expressly. It says advice of counsel is not a defense to contempt of Congress. So that was binding on the district court. It'll be binding on the DC Circuit panel on appeal. It will not be binding if the DC Circuit goes en banc. It will definitely not be binding if the Supreme Court takes this case. And if either of those things happen, right, my money is that the 1961 case gets overruled. I mean, anything could happen, but that's my prediction. And the reason goes to something that all the lawyers here learned about in the first year of law school in criminal law, and that's mens rea. So the mens rea for contempt of Congress, when somebody entirely disregards a subpoena, is willfulness. And that's a wily term in federal criminal law, but for the most part, ordinarily, what it means is violating a known legal duty. And so if the DC Circuit en banc, if the Supreme Court says that's what willful means here, well, then advice of counsel would be a defense, because if your lawyer tells you that you don't have a duty to comply with the subpoena and you believe that, then you haven't knowingly violated a legal duty. So I think there's a real chance here that Bannon's conviction ends up being vacated and the case goes back for a new trial. And if that happens, then Bannon gets to try to convince a jury that he believed his lawyer's advice and was relying on it. I'm pretty skeptical that Bannon could actually convince a jury of that, but it would be a much harder case for DOJ to win, a much less predictable trial than the trial that we've already had. And maybe more importantly, going forward, it would mean that to ward off any concern about a criminal contempt of Congress charge, a recipient just has to find a lawyer who will say that they don't have to comply for whatever invented reason. And that's not a foolproof defense, but it's something. So I think that this appeal could actually end up being more significant than people expect. So the other contempt case that's pending is Peter Navarro's, and it's pretty similar to Bannon, some slight wrinkles. So his executive privilege claim is a little bit more plausible. Still not a great claim, but at least it's a little stronger than Bannon's because he was in the White House. On the other hand, he does not have the plausible advice of counsel defense like Bannon does. So in that sense, his case is a little bit weaker, but we'll just have to see what happens later this year there. I want to move on, though, in the interest of time, to talk about the couple of cases that DOJ didn't indict. So Dan Scavino and Mark Meadows also referred to DOJ, but DOJ in these cases said, no thanks. So that means that the House's declination rate, to use the term we use in criminal law, was 50%. It's not a bad declination rate. And if the House was a federal law enforcement agency, that would be kind of in line. So on that level, not surprising. On another level, I think it is surprising because the statute that authorizes DOJ to prosecute these cases uses mandatory language. So I will put it up. There it is. So if you just read this, right, you might say, okay, well, DOJ doesn't have discretion. When it gets a referral from Congress, it has to present that to a grand jury, right? Not necessarily actually prosecute, but at least present the matter to a grand jury. DOJ has for a long time said no to that interpretation. So there's, OLC opinions that go back to the 80s, and they say, notwithstanding this mandatory language, U.S. attorneys actually have discretion to either present a case to a grand jury or not, as they see fit. Now, it is not at all clear that OLC is right about that, but until a court says otherwise, that's where things stand, and that's the discretion that the DC U.S. attorney used here. So why did the DC U.S. attorney do that? We don't know. So Bannon asked for discovery on the internal deliberations, and Judge Nichols very correctly said no. The best speculation that I've seen is in an opinion by Judge Maida in Navarro's case, where he rejected a selective prosecution argument. And he said, look, I can see a couple of grounds from distinguishing Navarro's case from those other ones. One is that in Scavino and Meadows, Trump had clearly invoked, or at least attempted to invoke, executive privilege, and that was really murky, or is really murky in Navarro. The other is that the people who weren't prosecuted did extensively communicate with the committee about complying before they ultimately walked away. So I don't know if that's what the U.S. attorney in DC was thinking or not. It seems plausible, even if it's not entirely satisfying as a reason not to pursue those cases. Last thing I'll talk about is on a separate track, and that's the Lindsey Graham subpoena case. So the basic fact pattern here is that before Georgia certified its 2020 results, Senator Graham had some contacts with Georgia election officials, maybe on behalf of the Trump campaign. So that's a pretty weird thing for an out-of-state senator to do. And so the prosecutor in Atlanta wanted to ask him some questions about it. So she serves a subpoena. Graham goes to federal district court and asks for an injunction. I'll talk about his theory in just a second. Case gets bounced around a little bit between the district court and the 11th Circuit. But in the end, the district court grants just a narrow portion of Graham's motion to quash. And specifically, the court says that the DA may not ask about information gathering that Graham did in talking to the Georgia officials, but that really wasn't a big deal because that's not what the Fulton County prosecutors wanted to talk to Senator Graham about anyway. They wanted to talk to him about his attempts to cajole, as the word that is used, the Georgia election officials to do something, right, that would give the electors to Trump. And the district court ruled that those questions by the DA were in bounds. And the 11th Circuit agreed with that, and then the Supreme Court agreed with that. So Graham's theory was speech or debate. He said, or his lawyer said, look, he was investigating what happened in Georgia to inform his decision about how he was going to vote on certification. And so the lawyer said everything he did in connection with talking to folks in Georgia is covered by speech or debate. So you can sort of see that theory, right? If we're talking about Graham asking questions to Georgia officials, but the logic, the Graham team's logic about why the speech or debate immunity could go beyond that, it was never very clear. The state application to the Supreme Court was really never able to offer a plausible explanation for how trying to influence a state official and how they do their job could be a legislative act. It was loaded with vague references to the original meaning of the speech or debate clause, and I can't really fault the Jones Day lawyers for trying that strategy. It did not work this time. And the court declined to issue a stay and said, look, the district court can deal with what side of the line particular questions are on a question by question basis. So Graham does testify. As far as we know, it's grand jury, so we might not know exactly, but as far as we know, there was no further recourse to the district court. And my sense is that this case is not going to have much in the way of reverberations. Graham's theory was like a Hail Mary pass at the end of a football game, and it didn't work, but those passes rarely do. So this case would have been a really big deal if it had come out the other way. But since the Supreme Court didn't do anything zany on this one, the status quo stays where it was.
Well, thank you so much, Will, for that analysis. These are going to be fascinating cases to watch over the next year. I think we have time for just one general question, so I'm just going to ask you this one. Some congressional experts claim that the caseload in the courts prove that Congress shouldn't be relying on the courts to protect their oversight authority. Judges take too long, they don't know that much about Congress, they're unpredictable. Some people are urging that Congress take its own actions to protect its oversight authority. Some say you should require courts to act in an expedited manner. Maybe Congress should be able to appoint its own prosecutor to do their contempt cases. Maybe Congress should impose civil monetary fines, something that's been talked about for years, but has never actually happened. Maybe we should revive congressional contempt proceedings. And of course, as Doug started us out with, getting that prison back in shape and throwing people in when they don't respond to congressional requests for information. What I'd like to ask all of you in a very brief time we have left before we go to our lightning round is, what do you think? What are your thoughts on strengthening Congress's own authority to protect its oversight, its power to investigate?
Should I go first?
Sure.
So, on the idea of Congress employing its own prosecutors, that raises a lot of alarm bells in my mind. So certainly constitutional ones. I mean, prosecution is certainly an executive function, and to see somebody not working for the federal government prosecuting in a federal court, to me seems like a pretty major deviation from how we do things. That said, there is a mechanism for Congress to do something that is very akin to a criminal procedure, and that is the inherent contempt power. It has largely gone unused, and particularly if the Bannon case is reversed for the reason I think it might be, and criminal contempt becomes next to impossible, maybe that ought to be rethought.
On the contempt point, I think it's good law and obvious that Congress can, in extreme cases, when it considers it justified, imprison someone. It's not at all resolved whether Congress can imprison the executive branch. If House Republicans arrested Biden's Bidens, that presents a major separation. So I think there's an appropriate distinction that power between private individuals, government officials.
Yeah, I've long been in the expedited judicial review camp. And I think I agree with Will that the congressional prosecutor raises serious separation of powers questions that, especially with the Supreme Court, I can't imagine them allowing that to go forward with their views on executive power. But I think that the last few years has shown how effective the judicial forum can be, and especially in the cases where courts did in fact set out expedited schedules, a lot got done. Is it a silver bullet? No, but that seems to me in recent years to have been the most effective way to vindicate congressional rights. And as time moves on and more of these cases get litigated, it provides clearer and clearer guidance for both branches as to what is going to be expected of people who are asked to testify. So that's just my view. I know there's lots of dissenting opinions and lots of arguments to be made on all sides, but that seems to me the most effective.
Just a couple of very quick reactions. I agree with a lot of what has already been said. By the way, remember that in the 1950s and 60s, the Supreme Court did overturn convictions of several people who had been, you had a Congress and the president, the Eisenhower administration, I think it was, on the same side. And so there were criminal prosecutions, and the Supreme Court reversed a batch of those. So I share Will's concern. Now you could say, well, you've always got the Supreme Court there, but gosh, I'm worried about just having congressional prosecutors. On the other hand, again, maybe the answer is fine, you got the Supreme Court. Second, this may have been what Andy was referring to, constitutional questions. Remember, there's a special, a restriction on Congress, bills of attainder. And I know, that's not a broad provision, but you have to be a little worried when Congress is actually criminally prosecuting. Then on the expedited, and by the way, these are things that we talked about at immense length within the House. On expedited review, I agree with Emily. The problem is it's not enforceable. The judges have life tenure. So you say the court shall issue a decision within 15 days. Okay, what if the judge doesn't? You can't say at that point, and then the subpoena shall be enforced if the court doesn't rule, right? And you can't say, and the subpoena shall be dismissed if the court doesn't rule. That doesn't work. So I know Congress in various statutes over the years has put in time limits, and the courts have said those are precatory, is that the word? Those, they're just sort of suggestions. And by the way, nobody's more frustrated than I am with the delay. So I wish it were different. And the last question is, I think Andy alluded to this. If it's private people, that's one thing. If it was Attorney General Doherty's brother in the McGrain case, that's one thing. He was a private citizen. But if you're dealing with executive officials, can you arrest them? I worked for a year when Eric Holder was Attorney General. I worked as his senior counselor. He had a massive security detail of highly trained and well-armed FBI agents. And I don't know what would happen if I used to joke with the sergeant at arms at the House when we were frustrated, like with Attorney General Barr. I suggested that he was the one person in the House who was in the Capitol, was validly armed, but his gun was locked in a safe. And I would suggest him regularly that it was time to get his gun out. I would walk him down to the Justice Department, and he could go in and arrest Attorney General Barr, who he did put in contempt involving the census documents. Unfortunately, as I say, General Barr had at his command, I think, about 5 or 6 heavily armed FBI agents on his security detail. So I don't know what the answer is, but now I did actually see General Barr up at the Capitol a couple of times, so maybe you could wait and then grab him then. As
Yeah.
you,
Well, I think we're seeing all of the issues about why it's so difficult to enforce Congress's powers to investigate. There are a lot of complicated questions. Well, it's 1:30, but I'm going to have us go a few minutes over so that everybody has a chance to do some concluding remarks. So let's take 2 minutes each, and we're going to go in reverse order this time. And so we're going to start with Will. Please give us some of your thoughts.
Yeah, I guess I'm struck through all of the different presentations by the extent to which exceptional circumstances lead to not only the development of law. I mean, we on so many of these areas, things were pretty staid for a long time, and then all of a sudden they're not. But also lead to really interesting law and maybe law that works well in exceptional times. And if we ever get back to ordinary times, we'll find out how they function there too. I think I'll leave it at that.
Andy.
So I found this panel very refreshing. Notice how much passion there is among us, and we don't care that the political optics have changed. I think there's just a lot of strong views, scholarly views on these issues that often get boiled into partisan warfare. And so I've really appreciated that none of us care about the political parties now that you have a Republican House and a Democratic president. Even though the case has emerged in a different political context, we are still all sticking to our longstanding guns. I'll just do the professor thing and refer to a couple of things I've written rather than respond to others. On the tax issue of Trump's release, I wrote something at the Yale Journal of Regulation. You can Google the IRS audits Trump. You can get everything on my view on that one. On congressional subpoenas, before Doug devastates me, or after Doug devastates me, I wrote an article in the North Carolina Law Review, Congressional Subpoenas in Court. That's my reply to my bitter devastation that is happening in a few minutes. And lastly, even though I'm critical of these cases, I have full confidence that Doug, in case I suggested otherwise, Doug absolutely presented his case as ethically and professionally. No reason to suggest he would misrepresent anything. I have a different view and strong passion about these. So thank you all to these panelists. It's gonna be a lot of fun to watch. I really enjoyed participating here. Thank you.
Emily.
Yeah, thanks. So yeah, I'm just struck by sort of as Will said, sort of the volume and the pace at which things have changed. I am curious, though I think that Congress, I'm in favor of congressional oversight regardless of which party is in control. I am curious to see, it seemed to me that having a friendly executive branch really gave the January 6th committee a leg up in a way that it would not have had the party in power been different. And so I do think that, unfortunately, while a lot of these principles are nonpartisan, I do think just as a practical matter, it makes a big difference who's in the majority and who's in the White House, and things that look like a legitimate legislative purpose at one moment to one set of people may not look so legitimate at another moment to another set of people. And so it'll be interesting to see, as I've said a couple of times, how much sort of staying power and generalizability a lot of these precedents have going forward.
Doug.
I have an observation and then a thought. I'm immensely proud of what my team, which included attorneys on committee staffs and in the Office of House General Counsel, and numerous pro bono attorneys who worked with me for totally free. By the way, I never spent a dime of your taxpayer money. These law firms and public interest groups and law school programs all totally free. So I'm immensely proud. But the one thing I want to say is, let's not make these court rulings more important than they are. And what I mean by that is, the reason that there was so little case law before on a lot of this stuff that I litigated is I think President Trump is the only president who ever said, I'm ignoring, congressional requests for information. I'm ignoring, I think he used the word all. I worked at the Justice Department for 40 years. Many, many times there were requests for information from Congress. The executive would say, go fly a kite. Then there would be discussions or negotiations, accommodations. And invariably material was turned over, sometimes pursuant to conditions. You can only, a left-handed per staffer can come over and can look for 3.5 minutes. And if they've got a photographic memory, that's fine. If not, too bad. The president and Congress have for decades and decades worked out negotiation and accommodation. And that's why I think there was so little case law. And so I think that in the future, other presidents are not going to be like President Trump. They're going to have a better, their administrations will have a better awareness of how the US government works and works properly in a democracy. And the executive branch and the legislative branch will go back to what they've been doing for many, many years of accommodation and reasonable negotiation. You don't get everything you want, but hey, that's the Rolling Stones knew that. Now with the private sector, obviously that can be different. If somebody doesn't comply, they could get criminally prosecuted. And but again, we have the Supreme Court to protect against inappropriate criminal prosecutions in that way. But I think we established some really good and important law, but I'm hoping that in the future, a lot of it is not all that necessary or relevant, because presidents and Congress, even when they're bitter enemies, will go back to working things out as they did for many, many decades. Elise, I know you were involved. You must have been involved in any number of situations like that. Thank you.
I want to thank our panelists for this amazing conversation. We covered so much ground, very complicated legal issues. I thought it was just absolutely fantastic. It will be interesting to see over the next 5 to 10 years whether this torrent of cases goes back down to a trickle. January 6th and President Trump are real generators of cases. And we'll just have to see if this Republican House also generates cases. And we'll have to see how the next few presidents handle the power of Congress to investigate. So again, I want to thank everybody. I thought this was very illuminating, and the Levin Center really appreciates all of your wisdom and expertise. So that's it. Jim, I don't know if you want to make any closing remarks. We're running a little bit over, so I'll leave it up to you. You're on mute, though.
I put myself back on mute. I love this conversation. I can't thank you all enough. Thanks to everyone who watched. And this will be a recording of this is going to be posted as soon as we have it available for anybody who wasn't able to join us today. Thank you all.
Thanks so much.
Bye-bye.